Basics of Employment Law. Introduction to the module. In the United Kingdom, there are around 4 million limited enterprises, which together may employ up to 21 million people on a full-time basis. Laws pertaining to employment in the United Kingdom are in place to guarantee the safety of both employers and workers. These laws, which include regulation on issues such as termination, vacations, salary, discrimination, and more, are in place to defend workers' rights while also preserving an employer's interests and maintaining an equitable relationship between the two parties. Topics to be covered in this module. What is employment law? Purpose the law serves. Areas the law covers. Unfair dismissal. Summary. 1.0 What is employment law? The rules and other legal issues that control the relationship between workers and their employers make up what is essentially known as UK employment law. It specifies what employers may demand of their staff, what they are required to supply, and what comprises the staff members' formal rights at work. Why is employment law so important? Because it serves to safeguard both employers and workers, employment law is crucial. Its goal is to provide everyone involved clarity on their working relationships. While it's common to think of laws as being about justice, it's more appropriate to state that employment law is equally concerned with providing clarity. In the end, employment law is important for UK companies since it may include legal frameworks into some of the most typical organizational procedures. These consist of hire procedures, processes for dismissal, the layoff procedure, how coworkers are handled. As laws have developed, new advantages for people have also emerged. Nevertheless, employment law also aids in preventing discrimination and successfully promoting equality, diversity, and inclusion at work. 2.0 Purpose the law serves. The labor law serves as a tool to further worker protection and empowerment. It controls both individual and group employment interactions. The Civil Code, Criminal Code, and the International ILO Conventions are some more pieces of pertinent legislation. The goals of labor law include redressing the power disparity between employees and employers, preventing wrongful termination of employees, establishing and maintaining procedures that acknowledge employees as equal stakeholders in discussions about working conditions, etc. By limiting the discretion of the contracting parties to negotiate their own terms and by establishing minimum standards for safety and remuneration, labor law attempts to stop a race to the bottom. A nation may decide to enact laws establishing maximum or minimum limitations on salaries or working hours, either nationwide or in certain sectors or industries. This governs the labor market. 3.0 Areas the law covers. When a position is posted, employment law governs everything that follows, including what happens to an employee's information after they leave a company. The following 8 elements of employment law are crucial: hiring and recruiting, employment agreements and working hours, statutory time off and leave, payroll, pensions, workplace health and safety, staff layoffs and dismissals, COVID-19 workforce FAQs and employment laws. 1. Hiring and recruiting. When it comes to employment law and hiring individuals, where do you even start? Are there guidelines and standards for posting a position, choosing the best applicant, and maintaining records? In reality, absolutely. Probably the best place to start when looking at rules that protect both workers and employers is the gov.uk website on recruitment and hiring. 2. Employment agreements and working hours. The most crucial employment legal advice we can provide you once you've made the choice to hire someone is to make sure they have an employment contract. Referring to this contract will usually settle any difficulties with UK employment legislation. 3. Statutory time off and leave. Everyone needs time off, and UK legislation ensures it. Nearly all employees are entitled to 5.6 weeks of paid vacation a year. This is also known as statutory leave. Other grounds exist for legal employee time off. For example, laws safeguard workers' rights to take sick leave and be paid, statutory sick leave and pay, and when someone they assist dies, compassionate leave. However, businesses should handle unclear problems like sabbaticals in employee contracts. 4. Payroll. Both teams must work together, even though handling payroll is often more of a financial problem than an HR one. This is true when it comes to notifying HMRC about a new hire and producing P45s, P60s, wage slips, and other formal documents. 5. Pensions. The pensions regulator is excellent for UK employment law and pensions. Whether you have 1 or 1,000 employees, you are deemed an employer under the Pensions Act 2008. According to the pensions regulator, any employer in the UK must contribute to a workplace pension system. Automatic enrolment. 6. Workplace health and safety. Employers must safeguard their workers' health, safety, and welfare at work under the Health and Safety at Work Act 1974 and the Management of Health and Safety at Work Regulations 1999. 7. Staff layoffs and dismissals. What occurs when employee ties are ended, such as when someone is dismissed, fired, requested to leave, or made redundant, is one of the trickiest employment law problems. 8. COVID-19 workforce FAQs and employment laws. Without including the COVID-19 Act, no essay on current UK employment law would be complete. 4.0 Unfair dismissal. Dismissal is the term used to describe the procedure by which a corporate official terminates a certain employee's employment. When the guidelines for dismissing someone are not correctly followed, it is considered an unfair dismissal. In the end, an unjust dismissal results from either not following the correct process for doing so or from the basis for the dismissal being unreasonable. According to UK employment law, if an employee has 2 or more years of continuous service with you, they have the right to sue your company if they feel they were fired unjustly. The following kind of problems might qualify as unjust dismissal: requesting leave for maternity or paternity, whistleblowing, bringing up safety and health problems, affiliating with a union, claiming one's legal rights, e.g., asking to be paid minimum wage. An employee is protected from the start of their job when it comes to addressing health and safety issues. 5.0 Summary. Laws pertaining to employment in the United Kingdom are in place to guarantee the safety of both employers and workers. The rules and other legal issues that control the relationship between workers and their employers make up what is essentially known as UK employment law. Because it serves to safeguard both employers and workers, employment law is crucial. Its goal is to provide everyone involved clarity on their working relationships. The goals of labor law include redressing the power disparity between employees and employers, preventing wrongful termination of employees, establishing and maintaining procedures that acknowledge employees as equal stakeholders in discussions about working conditions.